Hey folks, I'm Mark Smith, host of the Four Boxes Diner. For those of you new to this channel, I'm a constitutional attorney, a member of the Supreme Court Bar, and I'm proud to say that my scholarship in 2021 was cited by a federal judge in declaring California's so-called assault weapon ban to be unconstitutional under the Second Amendment. Now, if you love the Second Amendment and want to protect it, please hit the subscribe button right now. Help us spread the word through YouTube. Now, in my recent videos on Ukraine, we talked about the Second Amendment and armed citizens, armed Americans, thwarting potential foreign invaders and potential domestic tyranny, which is what the Founding Fathers intended the Second Amendment to do. Now, this, of course, my comments, I should say, prompted some anti-gunners to bring out some of their same old tired arguments along the lines of the following. The Second Amendment confers no individual right to own guns. It merely allows states to have militia. And today, that function is fulfilled, not by you, not by your viewers, but by the National Guard. Okay, I'm going to give you, just again, I've already done videos on this, but I'm going to do a quick one here, a few-minute summary of why all of us Americans help make up the foundation of that well-regulated militia that the founders envisioned. And I'm also relatedly going to explain the handful of historical, textual, and constitutional facts you need to know to demonstrate why we all have an individual right to keep and bear arms. Okay, here are the basic facts you need to know about why we all have the right to keep and bear arms and why we all, as American gun owners, ultimately can comprise and make up a militia if needed for national emergencies and whatnot, okay? But most importantly, I want to explain why the phrase a well-regulated militia does not suggest in any way, shape, or form that we don't have an individual private right to keep and bear arms here in the United States. Okay, first of all, the Second Amendment states unequivocally that the people have a right to keep and bear arms. This does not create the right to keep and bear arms. This is very important. The language of the Second Amendment confirms or reaffirms a pre-existing God-given right to keep and bear arms. This is why the founders wrote the phrase, the right of the people to keep and bear arms shall not be infringed. It presupposes the existence of the right to keep and bear arms, which, as you know, effectuates the human right of self-defense. And if you're a theologian or religious in nature, of course, what God giveth is something you have an obligation to protect. So if God give you life, then you have an obligation to protect that life through means of self-defense. Okay, it's also a religious-based as well. Okay, the second thing to understand about the right to keep and bear arms in the text of the Second Amendment is where do we actually find the Second Amendment itself? You see, it's in that part of the United States Constitution that talks about individual rights. It's in the Bill of Rights. It's not in the Bill of Government Powers. Remember, and keep this in mind, individuals, you and I, we have rights. Rights. Governments don't have rights. Governments have powers or authority. So the fact that the Second Amendment appears in the Bill of Rights means it's about individual rights and not governmental powers. Third thing to understand is that the U.S. Supreme Court and the Department of Justice, by the way, but most importantly, the United States Supreme Court in the District of Columbia versus Heller in 2008, and then again in subsequent cases, concluded unequivocally that the Second Amendment protects an individual right to possess a firearm, unconnected to service in the militia, and to use that arm for traditionally lawful purpose, including but not limited to self-defense. That the Supreme Court reiterated this view from Heller 2 years later, in 2010, in the case of McDonald versus Chicago, which applied the Second Amendment to states and localities, and again in 2016, in the case of Caetano versus Massachusetts. And in my view, it will likely reaffirm this principle that the Second Amendment protects an individual right to keep and bear arms for you and for me, individually, privately. This year, in a case called Nyserpa versus Bruin, which we will likely see decided in June of 2022. Now, the fourth point I want to make in this video concerns the significance of the opening language of the Second Amendment that mentions a well-regulated militia. This is known as the prefatory clause. The prefatory clause. You see, the rest of the amendment, that's the part that talks about the right to keep and bear arms, okay, is known as the operative clause, the operative clause. The key word here is operative. The operative clause tells us what the actual protected right is. The operative clause says plainly that the right belongs to the people, not to National Guardsmen, not to the Army, not to the military, not to the government. Now pay attention, please. You see the prefatory clause that refers to the well-regulated militia, okay, does not change the meaning of the operative clause. Instead, the prefatory clause of well-regulated militia states an important one, but not the only, important reason for the operative clause to exist. And the operative clause, the right of the people to keep and bear arms, facilitates the realization of the prefatory clause, which refers to a well-regulated militia being necessary for the security of a free state, okay? And why is that? It's because the founding fathers of the United States believed that a well-regulated militia meant a militia that consisted of all the people, the whole people. It was not about government regulating or controlling the militia, like the IRS today issues regulations to govern income tax collection. No, that's not what it's at all about. You see, the militia is drawn from we the people, and it presupposes that we the people will have our guns, which is how the Second Amendment is written. And if a militia is required to be raised for some particular national security reason or whatnot, to protect against, let's say, a foreign invasion, okay, well, then there would be an armed citizenry from which to draw in order to have a well-regulated militia. Well-regulated meaning not regulation like EPA regulation or FDA regulation today. Well-regulated at the time simply means effective or competent, okay. Now the fifth point I want to quickly make here is never forget the existence of the Militia Acts. There were two of them. The Militia Acts of 1792. To put this in perspective, in the year 1791, that's when the Second Amendment was created, okay. A year later, not even a year later, in the year 1792, the Militia Acts were passed by the first Congress. And the Militia Acts demonstrated the founders' understanding that Americans, you and I, all have a private right to own guns. You see, months after the Second Amendment was ratified, President George Washington, right, the founder of our country, signed that law into law. Okay, and that Militia Act spelled out what supplies militia members needed to bring to militia service. Anyone who joined the militia, the law said, must, quote, provide himself with a good musket or firelock, a sufficient bayonet and belt, 2 spare flints, and a knapsack, a pouch with a box therein to contain not less than 24 cartridges. Now, did you catch that? Each militia member had to provide himself his own firearm and his own ammunition, okay? But how could someone bring his own gun if the citizens had no right to have them in the first place? Right? Think about that for a second. If the founders intended the Second Amendment to mean what the anti-gunners argue, that there's no individual right to keep and bear arms, then there would be no one experienced enough or with the requisite supplies, musket, cartridges, ammunition, to make up the militia under the Militia Act of 1792 or beyond, of course. And the sixth point I want to mention is talk about the word militia, okay? Now, during the Virginia ratifying convention, George Mason said, quote, "Who are the militia? They consist of the whole people, except for a few public officers." Okay, and during the Massachusetts ratifying convention during the time of our founding, Samuel Adams, not the guy that did the beer, but he's kind of named after that, right? But during the Massachusetts ratifying convention, Samuel Adams declared that the Constitution should never be construed to authorize Congress to prevent the people of the United States, who are peaceable citizens, from keeping their own arms. Or listen to the man who wrote the Bill of Rights himself, the guy who actually wrote the Bill of Rights, James Madison. In the Federalist Papers, specifically Federalist Paper 46, James Madison wrote that a militia of ordinary citizens would resist government tyranny, a lesson we talked about in other videos that Ukrainians should have learned many years ago, but apparently they did not. And unfortunately, they potentially are suffering the consequences of failing to learn that lesson right now. Most unfortunate, but that's the reality of it. Okay, James Madison back then asked his readers to consider what he thought to be an unlikely scenario, but still possible, an unlikely scenario, but a possible one, in which a tyrannical standing army emerged that was entirely at the devotion of the federal government. But don't worry, you see, Madison said about our Constitution that he was proposing. Opposing that standing army would be, quote, a militia amounting to nearly 500,000 Americans, or he called it 500,000 citizens, with arms in their hands, officered by men chosen from among themselves, fighting for their common liberties. That was James Madison. Powerful language. Now, Madison also said that Americans possessed an advantage over the people of almost every other nation. Well, what was that advantage? It was the advantage of being armed, he wrote. You see, governments in Europe were afraid to trust the people with arms. That's what Madison said, not me, Madison, the writer of the Constitution. Not that the United States, though, not the United States. The United States had arms and armed citizenry. And that's the case today. Now, of course, in today's world, I would argue that the anti-gunners really don't trust us with guns. They don't want us to have guns. They don't trust us. They think we should be government subjects and not citizens. I think we should be citizens. That's what the Constitution intended, and I think that's what Americans want to be, citizens and not subjects. But we already know this, didn't we? And we know that the far-seeing men who wrote the Constitution and the Bill of Rights, our founders, wanted all of us to be citizens, including armed citizens, and not subjects like you see in places in Europe. Unfortunately, arguably, what we saw leading up to the Russian invasion of Ukraine. Okay, well, I hope you learned a little something here today. Thanks for watching the Four Boxes Diner, and stay tuned for more Second Amendment information. And of course, if you haven't subscribed yet, don't forget to do so. That really helps us out here at the Four Boxes Diner.
Orders up. Table 2A.